Welcome to the Faculty of Law. I'm Deborah Parks. I'm chair of our Distinguished Visitors Committee here at the faculty. And it's my great pleasure to introduce my colleague, Brenda Gunn, who is going to in turn introduce our guest speaker for today. Brenda Gunn is a member of our faculty who researches and teaches in the area of Indigenous peoples and land and rights, and is with a particular focus on international Indigenous rights. And she's just a wonderful member of our faculty who has very recently been actively involved in coordinating the successful Indigenous Bar Association conference, which was held here in Winnipeg last week. And our guest speaker was here in conjunction with that, and so we're very fortunate to have her here today. So over to Brenda.
Thanks, Deborah. I'm very happy to be able to introduce to you Jacinta Ruru. She is an associate professor at the University of Otago in New Zealand, Aotearoa. And I'm so excited that she was able to be here. When the IBA said we were going to do a conference on water rights, I said it would be great to bring in some international perspectives because there's a lot happening around the world. And so I spoke with some of my Maori colleagues and I said, so who is the leading Maori scholar on Indigenous water rights? And they said, Jacinta. So I said, well, let's see if we can get her over. And fortunately, her and her husband and 2 kids are currently based out of the US. They are both senior Fulbright scholars and doing work currently in Phoenix at the Sandra Day O'Connor Law School there. And her work, I just quickly printed out her bio online. It's 5 pages long, so I'm going to excerpt it a little because I think trying to note all of her research contributions in this area would take up too much of her speaking time, and I want to make sure that she has the time to speak. But her area has been around management, ownership, governance of both land and water. I initially met her via email working on when she submitted a paper to the Indigenous Law Journal when I was a student, and that was on management of mountains, and just captured, I think, the entire board, just her way of writing and way of thinking of these issues. So after knowing of her work for over 10 years, it's so exciting that she's finally here today to talk to us, not as much about Indigenous water rights and things happening in New Zealand, but also looking at constitutional jurisprudence and the Treaty of Waitangi. And I think, again, she's going to share some amazing information that we can use and think about how it applies here in a comparative context in Canada. So with that brief introduction, I would like to welcome Jacinta Ruru up here. Thank you.
Tēnā koutou katoa, ngā mihi kia koutou, ko Jacinta Ruru toko ingo, no Ngāti Raukawa, me Ngāti Mani o Poutou, ngā iwi. Tēnā koutou, tēnā koutou, tēnā koutou katoa. So just in my language, I've just said hello and greetings and explained briefly who I am. First, I want to acknowledge the Indigenous peoples of Turtle Island, in particular Treaty 1 and the Métis people from here, tēnā koutou katoa. It's such an honour to be here with you today as part of this distinguished lecture series and to talk about constitutional rights that stem from our Treaty of Waitangi, a treaty that was signed in 1840 between most of our Maori chiefs and the British Crown. And particularly at this time when Canada is marking the 30th anniversary of the enactment of Section 35 of the Constitution Act. So my heartfelt thanks to Dean Lorna Turnbull and to Professor Deborah Parks and Brenda Gunn for this most generous invitation to be here with you today and for your hospitality. So to begin, I'm going to start kind of with a story. It's not the way I usually start with a lecture. But so according to my father's ancestors, our land is Papatōnuku, our Earth Mother, and the sky is Ranganui, our Sky Father. A long time ago, our primal parents lived close to one another in a tight embrace. As the children began to grow older, they longed to escape from their parents and hatched a plot to flee. After much trying, the young son, Santane, eventually succeeded by lying on his mother's back and pushing his legs against his father. And through that, the world of light entered, so separating our primal parents. As the explosion of light entered their domain, a new world was created, what we call Te Ao Marama, the world of light, which is what we live in today. All but one of the children marvelled at their freedom. Tāne, the strong one, became god of the forest. Tangaroa became god of the sea. Rongo became god of cultivated food. And so we have all these gods for our environment. And the one that was angered at the separation, Tāwhiri Mātia, became god of winds and storms. And as these stories of creation are told, such as this one, valuable lessons for the daily life are imparted. It was important to my ancestors to respect all that surrounded them, for us to see ourselves as tangata whenua, people of the land. And while my ancestors were far from perfect, greed and warfare were rife, they had developed a society that worked. They had an intricate language, the greatest memories for storing information, and complex laws for creating order. My ancestors' ways have since faced what hopefully has been the greatest challenge to our existence, colonisation, and survived. When the Europeans, who are also my ancestors, began arriving on these shores of Aotearoa, New Zealand in the late 18th century, they brought with them a different but also valid way of viewing the world and a different way of doing things. But as the Europeans began to take hold in the country, they pressed their new ways onto the first peoples who had called these lands home, eventually overlaying Papatonuku, our Earth Mother, with a new language, new resources and new laws. They sought land for settlement, and while they signed a treaty with most Maori tribes in 1840, that Treaty of Waitangi, which agrees to respect Maori property rights, the newcomers' desire for land that Maori did not want to sell eventually led to a decade-long war in the 1880s. After the drawn-out battle, where the result was somewhat indecisive, the newcomers turned to their law in an attempt to gain the land, and through this law, the newcomers declared the first peoples uncivilized, primitive, and savage. They used these fictions to claim that Māori lacked rights to property, and these laws cut deeply into Papatonuku. In the next 100 years or so, Māori were unable to hold on to all that was dear to them. Today, with so little land left in the hands of Māori, the courts are finally rethinking their earlier precedents. The courts and government are shaping and reshaping the relationships with Māori and are beginning to grapple earnestly with what it meant to sign that Treaty of Waitangi all those years ago. So in particular, in the 1980s, Aotearoa, New Zealand, like Canada, sought to more formally recognise their Indigenous peoples in the law. As you know, in Canada, in 1982, the new Constitution Act was enacted with Section 35. In Aotearoa, New Zealand, we do not have a formal written constitution like Canada, but in 1986, the first statute was enacted that gave some significant legal standing to the Treaty of Waitangi. And I'm going to talk more about that in today's talk. As part of this introduction, though, the judiciary in both countries have since contributed enormously to defining the Indigenous reconciliation discourse. At times, the New Zealand and Canadian courts have gazed at each other, sometimes with approval, but the legislative mechanism to recognise Indigenous peoples is obviously different. In Canada, it has been via a formal constitution recognition, whereas in Aotearoa, New Zealand, it has been via ad hoc statutory incorporation. The New Zealand judges are alive to this difference, although there is conflict as to whether the difference is significant or not. So one thread of the general sentiment is that there is similarity, even though Canada has the Constitution Act and New Zealand has the Treaty of Waitangi. And there should be no inference that, and I'm quoting, the rights of the Māori people are less respected than the rights of Aboriginal peoples in North America. In contrast, some of our cases, judges have been stating that the Canadian cases are irrelevant because they reflect the different statutory and constitutional context in Canada. My talk today draws from a larger paper that I've been working on that is considering the developing legislative and judicial considerations of the Treaty of Waitangi and whether it provides similarly or not to Section 35 here in Canada. So I'm honoured to be with you here today, and I wish to squeeze into like the next 25 minutes a quick overview of just Māori and the treaty, and then again very quickly Māori role within central and local government, and then turn to more of the crux of what I really want to explore, but I don't imagine I'll have too much time, as to how Parliament, the courts and our Waitangi Tribunal have viewed the treaty. Do they view the treaty as a constitutional document or not? So, let's start this. So Māori first discovered and settled the lands and waters of Aotearoa, New Zealand, sometime on or after 800 AD, so a significant time after Aboriginal peoples first found Turtle Island. The Māori tribes became literally the people of the land, tangata whenua, with a common language with some regional dialectal differences that reminds us daily of this relationship. For example, iwi means tribe or bone, hapu, sub-tribe, to be pregnant, whānau, family, to give birth. You see this relationship between who we are and where we come from. Whenua is land, but also afterbirth. And then tangata whenua, the one I've been using a few times already. In fact, the law today recognises the Māori language as an official language, and it's quite common for our legislation now to reference Māori words within our legislation, sometimes with definitions and sometimes not. Today, Māori are visibly present throughout the country, currently constituting over 15% of the population, again quite a difference to Canada here. And Māori are integrated into all parts of society and share a long history of intermarriage with Pākehā, with Māori, the Māori word for Europeans, and others. And I thought I'd just very quickly again put up the identity of who is Māori. The first point there is in legislation. So again, it's quite different to what happens here in North America, including in Canada. Our legislation has just been quite open really around who is Māori, and then the bottom part there is a quote from one of our leading Māori jurists, Moana Jackson, really confirming that this is the Māori position. So when children are born with whakapapa, that's our genealogy, they are grandchildren, or mokopuna is grandchildren of the iwi of the tribe, they are Māori. So it becomes more of a self-identification part. So in 1840, let's talk a little bit about our Treaty of Waitangi. Many Māori chiefs officially consented to Europeans living in Aotearoa, New Zealand, with the signing of a bilingual Treaty of Waitangi. This is one single treaty. The Māori language version, which contains the most signatures, records that Māori would retain tino rangatiratanga, or Māori sovereignty, over their lands and treasures, but otherwise gave governance rights to the British Crown. Now in the English version, which has some significant translational differences, it states that Māori ceded sovereignty to the British Crown, but Māori retained, still quite a strong acknowledgement here in the English language, full, exclusive and undisturbed possession of their lands, estates, forests, fisheries and other properties. In 1840, the British assumed formal sovereignty of the country, and many Māori tribes were unhappy with the colonial government regime right from 1840. Some protest action was peaceful, travelling to England to petition the Queen, and some was more violent. And by the 1860s, that violence had escalated into a decade-long New Zealand land wars. And even to the next, 150 years, still there are issues of the Crown breaching our principles of the Treaty of Waitangi, even in a contemporary context today. However, since 1975, Māori have had an opportunity to present arguments to a specially created Permanent Commission of Inquiry the Waitangi Tribunal on alleged Crown contemporary and historical breaches of the principles of the Treaty of Waitangi. This Waitangi Tribunal was made up of both Māori land court judges and other notable persons from throughout the community, maybe historians. It's a bicultural commission, so it's both Māori and Pākehā or non-Māori sitting there making these decisions. So it's a powerful bicultural place where hearings are often heard on marae, so Māori meeting houses, with Māori protocols and Māori language often utilised. The tribunal has released numerous reports on tribal areas and more generic issues ranging from the use of the Māori language, customary fishing, allocation of radio frequencies, petroleum, aquaculture and more recently water. In some instances the government has accepted the tribunal's recommendations for redress and enacted appropriate legislation. In other instances has just denied or ignored the tribunal recommendations. On the same track of thought, Māori are regaining control of their affairs, boosted by Treaty of Waitangi claim settlements. So since the mid-1980s, the Crown has sought to engage in a fair and final settlement process of claimed historical breaches of the treaty. The settlements aim to provide the foundation for a new and continuing relationship between the Crown and the claimant group, based on the treaty principles. So our settlements all contain extensive Crown apologies to Māori, quite often utilising Māori language features like proverbs, waiata songs. And it's a unique and amazing thing to have a look at one of these settlement statutes to actually see that Māori language being incorporated into there and the extent of the Crown apology, an unreserved apology to Māori coming through in those settlement statutes. And as I said, there's some commercial redress that goes with that, some financial redress that goes with that, and then more cultural redress, which might be enabling Māori to have more opportunities for decision making around natural resources. Some significant cultural redress examples here includes the return of pounamu, so this greenstone that I'm wearing today, to Ngaitahu. So Ngaitahu own all this stone now, found in its natural state, and the new co-management of the Waikato River is a significant initiative. More than 20 tribal groups have now received redress. And in addition, there's been some financially notable pan-tribal settlements. If anyone knows anything about Aotearoa, New Zealand, and any settlement, it probably would be our commercial fisheries settlement, where Māori have a percentage of the quota of our commercial fish, have a 50% ownership of our Sealord company, the biggest fishing company in New Zealand, Sealord company. So there's quite amazing stuff happening there on that commercial fisheries front. There's also been pan-tribal settlements for commercial aquaculture and forestry. The increased wealth of the tribes has enabled Māori to have more national political clout and the means to work with their tribal members to grow their tribal assets and provide many social benefits. So Māori and the government generally... this is just a little picture. I showed it at the IBA conference. It's my chief of my tribe signing with our Minister of Treaty Settlements the co-management agreement for the Waikato River. So moving generally to around this relationship between Māori and government, including central government and local government, a couple of points that are different to here in Canada. One is we have a unicameral parliament, so just one house, one chamber. And the significant point, and one that we grapple with, but maybe it's a good thing, is that Parliament is supreme, which means we don't have a written constitution that is entrenched in the way that's going to bind or influence our Parliament. The legislation that our Parliament makes, or what our Parliament does, that's it. Our Parliament is described as being sovereign or supreme. A little bit more about our Parliament. So our Parliament, our House of Representatives, initially up until 1996 was under first past the post voting system. In 1996 we moved to mixed member proportional voting system, which is a total of 100 seats in Parliament. MMP allows for more parties, a more diverse range of parties to come into Parliament, and it's been impossible since MMP has been in place for one government to govern on its own. So it's had to have the support of minor parties, which has really increased the opportunity for Māori to have a role in government. So since 2006, have I got my dates right? So the Māori Party was first established in 2004, and since 2006, I think, has had a confidence and supply agreement with our national-led government. And that has meant that a Māori Party minister is our Minister of Māori Affairs and has been able to influence policy. And you'll see, and I'm going to point to one of the initiatives in a moment, is around constitutional review. And as part of this, also significantly and very different to probably anywhere else really, is that Māori have had guaranteed representation in our Parliament, in our House of Representatives since the 1860s. 4 seats were reserved for Māori. Why? Because at the time in the 1860s, the rule was that you could vote if you owned property. In the 1860s, Māori still owned a lot of property, still one of the major landowners in the country. And Māori still outnumbered Pākehā Europeans in the country. And so to allow Māori to vote would totally skew Parliament in favour of Māori, and the British colonial government didn't want that, and so they ring-fenced Māori into these 4 seats, so Māori could only vote in these 4 Māori seats. It's meant that Māori have had Māori in Parliament, Māori representation since the 1860s. Since the 1970s, Māori have had a choice as to whether they vote on the Māori seat or on the general roll. And with the introduction of MMP in the 1990s, those Māori seats have been able to increase in accordance with population. So we now have 7 seats, and we're on the cusp of gaining 8 seats in Parliament. There's also a lot of Māori who come in just with their own parties on list seats or as MPs in other regions. I think there's about 20 Māori MPs all up, and 120. Which is a bit more than our population, about 15, well, maybe about the same, 15% population with about 20 MPs in Parliament. I was just going to explain, I'm running out of time, so I'm not going to do that. I was just going to explain around Māori ownership of land. So all land in New Zealand was Māori customary land. There you'll see from 1840 to the 1860s, the Crown had that right of preemption, so was the only one able to purchase land from Māori and then would on-sell it as general land. Again, it's another very unique factor in Aotearoa, New Zealand, that's not replicated anywhere else, is that in the 1860s, the government established our Māori Land Court, or Native Land Court, with the sole purpose of transferring Māori customary land into this intermediate, really, Māori freehold land. And the owners of Māori freehold land were then encouraged to sell their land either to the Crown or to whoever they liked, really. The reality and the whole purpose for creating this Māori freehold title, the Native Land Court, was to act as a colonial tool to take land from Māori into general ownership. And so for Māori to be able to do anything with their land, they'd have to get a freehold title to it, so they have to make it Māori freehold land. But the process of making it into freehold title would have to incur costs for surveys, for actually daily appearance in a court, where that court was often sitting in the cities, and so they'd have to have accommodation because they're away from their rural-urban areas, rural homes. And so very often, even if Māori were successful in getting that certificate of title to say that they owned that land, would come back home with huge debt and would have to sell that land. And that was really the purpose of the legislation. You can see the purpose of the legislation was around destabilising Māori tribes and encouraging the selling of it, to the extent today that only 6% of the country is in Māori freehold land ownership. It's owned in common. Māori don't often reside on it. It's kind of land, for the general part, that's not very valuable, sort of the leftover land. Although there's some great initiatives since 1993 to try and help revitalise Māori freehold land. And we're struggling with it as a country to deal with. Local government, again, just very briefly, particularly from our Treaty of Waitangi settlements, Māori have rights under our Local Government and our Resource Management Act to participate in some decision making. Some regions, like our Bay of Plenty, actually have guaranteed representation. So I've spoken about that at the central level. Actually at that local or regional or what you call provincial or territorial level, Māori have rights or seats set aside for them to be able to participate. And then also, because of Treaty of Waitangi claimed settlements like that Waikato River one I said, that it's introducing a co-management of the longest river in our country. That co-management regime is enabling Māori to have joint management decision-making with the local government around the use and allocation of the water within that river. Back to the actual Treaty of Waitangi itself, and as I said in terms of Parliament, the Parliament is supreme, and as part of this, the Treaty of Waitangi only usually becomes relevant if it has been expressly incorporated into statute. We had a Privy Council decision in the 1940s that said the courts cannot have recourse to our treaty unless it's been incorporated into legislation. That statutory incorporation has been relatively recent. Until sort of the 1970s, the treaty was openly described as a simple nullity by our courts. So the Treaty of Waitangi Act that established the Waitangi Tribunal was our first statute to use the term the principles of the Treaty of Waitangi, but the first statute to do so in a way that would limit decision-making powers came through in 1986. So this is the first time we actually have our treaty put into legislation that's, as you said, not going to permit the Crown to act in a manner that's inconsistent with the Treaty of Waitangi. And wow, this just opened an amazing opportunity for Māori. Straight away went into the courts and we're going to stop a Crown government transferring Crown assets into a state-owned enterprise. And so this case allowed Māori to go into the courts right up to our then top domestic court, which was our Court of Appeal, to argue the strength of the Treaty of Waitangi. And I'm going to talk about that case, that's the lands case, in a moment. But I think I've got some other in between that. So since that 1986 case, we now have 109 statutes that reference the Treaty of Waitangi. And this is just, I've just put up this and this. So 2 slides of the most recent statutes from 2006. The idea there is just to, I don't know if you can even really read it from where you're sitting, but just to get an idea that across nearly all areas of our law, as a reference, decision makers are having to take some regard of our Treaty of Waitangi. You'll see the Income Tax Act, I don't even know what it actually says, the Evidence Act, all our environmental legislation. But it is interesting, and actually I'll just say that's the way that the treaty principles are usually referenced in legislation. So either to give effect, give particular recognition to. And as lawyers, there's a lot of significance in these words. That give effect to is the strongest legislative mandate. It's only been used once in the Conservation Act in 1987. Since then, the Parliament has been more comfortable referring to the treaty more and either, have regard to the treaty principles, but you also have to take into account a whole lot of other principles. And the treaty doesn't have any veto in terms of decision making. But as long as in your decision making you can show that, you've thought about the treaty, well, then you're complied with the legislation. So, talking about the courts, how have the courts interpreted or discussed the Treaty of Waitangi? Our courts, and this is the lands case that I spoke about, just mentioned, the lands case in the 1987 case that came from that state-owned enterprises Section 9 is probably our founding decision on the Treaty of Waitangi, a 1987 decision, landmark decision for reconciliation of treaty jurisprudence, and quite strong, that the treaty is a living instrument. So this is the first case to overrule that earlier case law that had described our treaty as a simple nullity. So the court is really having to deal with that simple nullity precedent and overrule it, and instead is describing the treaty, as a living instrument, positive force in the life of the history of the nation. And I want to compare, what I'm going to do in the sort of last 5-10 minutes is I'm comparing the slides here between what our court has done and what our Waitangi Tribunal has done. And you'll see that our Waitangi Tribunal has been so much stronger and so much more proactive around the treaty. But that's a good start by the courts there. So our Waitangi Tribunal really has explored and really, from sort of quite hesitant beginnings, just as a basic constitutional document, right up to our most recent tribunal decision here, constitutional document of overriding significance for our country. I think I'm just going to leave my notes. I'll come in and just... and then how have the courts actually interpreted the treaty principles? Partnership, reasonableness and good faith were sort of the hallmark of the treaty principles back in 1987 in that Lands case. Really emphasised partnership, that Māori and the Crown are partners and need to work together as partners. The courts, as you can imagine, since then have been backtracking from that really strong language. You then have that reasonableness, mutual cooperation and trust. Now this is what the Privy Council emphasised in 1994 as what the treaty principles mean. So no longer using that word partnership. And a lot of this is trying to put forward, and all the courts are very adamant that the Crown has the right to govern, and in the Crown's right to govern, it needs to, to act in good faith with Māori around decision making and looking for options, but in no way is government bound by the treaty. And that contrasts really with the Waitangi Tribunal, which has been really, really strong about reciprocity, which is a principle that the courts themselves don't really push forward. And so the Waitangi Tribunal is saying, okay, the Crown has a right to govern, but it's qualified by Māori sovereignty, Māori tino rangatiratanga. The Crown has a right to make laws with careful, reasonable balancing, and the Crown can override rangatiratanga in exceptional circumstances, but it would have to be in the national interest, and compensation would have to be owed to Māori. It's really quite amazing and in-depth jurisprudence being developed by our Waitangi Tribunal in contrast to our courts around what the treaty ought to mean. Now the courts have said that they can use the Waitangi Tribunal decisions as a guide in their decision making, but it's not precedent. They don't need to follow the Waitangi Tribunal decision making. Remember, the Waitangi Tribunal is that special commission of inquiry there to make recommendations to the government that the government can then ignore. And some of my work, and particularly my PhD, which I had the amazing opportunity in 2006 to live on Vancouver Island and to do my PhD through UVic under the supervision of Professor John Burrows. And that PhD, which I've just completed, I'm so excited about, is a comparison around Indigenous people's rights and responsibilities with national parks. And I've compared New Zealand, and in New Zealand our strongest legislative reference is to Section 4 in our Conservation Act, where our Department of Conservation, who manages national parks, must give effect to the treaty principles. And if we look at the Canada National Parks Act, Section 2, subsection 2, references explicitly Section 35 of the Constitution Act. So what does it mean when we have national park legislation that references the treaty on one thing, or Section 35, so real strong acknowledgement to Indigenous peoples, what does it mean on the ground and how have the courts interpreted that? And why, in particular, I was very interested in case studying national parks is that, well, in New Zealand anyway, a third of the country is in national parks. So a large chunk of our country is protected and preserved in national parks, and most of that land are our mountains, our rivers, really important lands that are absolutely essential to Māori identity and how we identify ourselves, have been taken from us, and well, not taken from us under an assumption that no one owns that land because it's wilderness, and that so therefore the Crown has the right to be able to manage it. And so my PhD was really looking at this, and the way I wanted to link it in today's talk, well, okay, New Zealand doesn't have an entrenched the Treaty of Waitangi isn't entrenched in any sort of veto kind of way, or maybe it doesn't have the same standing as Section 35 of your Constitution Act, but we have the Treaty of Waitangi. And how have the courts interpreted that? The courts haven't yet actually had to decide the really hard decision as to the meaning of the Treaty of Waitangi in the context of managing national parks, but they have looked at the Section 35 in the Constitution Act in terms of Māori right to marine mammals, and in that particular decision, this is the precedent here, only where provisions in the statute are not inconsistent with treaty principles. So a provision like preservation, which is in national parks, could override the treaty principles and override a Māori relationship with the land, which isn't normally described as protection or preservation, would be more about sort of sustainable link in and use. Waitangi Tribunal, very, very different, very, very strong around what that Section 4 of the Conservation Act ought to mean. Again, sort of stating here that Crown's right to govern is subject to Māori tino rangatiratanga. The national interest in conservation is not a reason for negating Māori rights to property. And if a resource is a taonga, a treasure, the Crown is under an affirmative obligation to protect it. And as part of that, some of this that Waitangi Tribunal, the courts is quite similar to the way that the Canadian courts have interpreted Section 35 in terms of being justified and being able to depart from recognising Aboriginal interests. So it's not Section 35, although it's very strong wording, doesn't give Aboriginal rights any sort of veto rights and then I looked in my PhD around the case law deriving from the Canada National Parks Act, and where there's actually been some wins. And there was a win, obviously, with the Mikisew Cree case with Treaty 8 lands around building a road through the national park, and Aboriginal peoples up to the Supreme Court of Canada. Okay, they got a win there. So, if I just jump my notes here, if anyone's interested in this, do have a paper here that I'm more than happy to share with you. I just sort of want to get to, not that point, this point here. So in terms of our treaty and the role of the treaty within our legislation, the Parliament is obviously aware of it, the courts are aware of it, everyone in New Zealand is sort of aware of our treaty, and for more than 2-3 decades now we've been really trying to work with the treaty. Nonetheless, Māori still constitute all the wrong side of the statistics for health, education, imprisonment and unemployment. Past legislation legitimated horrendous actions against Māori, including taking their lands and treasures and encouraging the demise of Māori language and Māori culture. While the country is reconfiguring towards reconciliation, the relationship between Māori and the government and society generally is still tense at times. And these are pictures taken from 2003 and 2004, when our Court of Appeal said that Māori could argue in the court's ownership of foreshore and seabed. That week, as soon as that decision was made, government said, no way, we're not letting Māori have that opportunity to go to the courts to argue rights to property in the foreshore and seabed. We're going to pass clear and plain legislation that states Crown owns foreshore and seabed. And Māori and a lot of others reacted to that. And this is Māori here, 20,000 Māori protesting that passing of that legislation at Parliament. And again, right now, if anyone was at the Indigenous Bar Association conference, we're at another loggerheads moment in our race relations around water. The government is going to move Mighty River Power Station, which is a hydroelectricity power station, from a state-owned enterprise into a mixed ownership model, which means up to 49% of the shares are going up for sale to the public. Māori have said, well, no way, Māori, we own this water. If you're going to go ahead and do this, you have to resolve those ownership rights with us, and if you're still going to go ahead with it without returning ownership to us, we need commercial redress for this. And so that went to the Waitangi Tribunal. Waitangi Tribunal agreed, released its decision end of August. The government said, okay, we will delay the putting up of the shares on the market until early next year and enter into a short consultation period with Māori. That short consultation period with Māori ended last week. It was a farce. The government put up ideas around a share plus model, basically giving Māori some shares and then potentially some involvement in the running of, well, sort of on the constitution of the Mighty River Power Station. But the government said, okay, this is a Waitangi Tribunal option. We actually don't believe in it, but we'll go out and speak with you Māori and see what you think. So not many Māori even turned up to their consultation hui. A lot of Māori boycotted it, under the direction of our Māori king, actually. So last week, government ended that consultation process, and Māori have now said, right, we're going to the courts. We're going to the Court of Appeal. We're seeking an injunction to stop the government from proceeding to this. So we've still got huge, huge issues in our country and trying to work out our relationship between Māori and government and coming back to the basics of our Treaty of Waitangi. So the Treaty of Waitangi is a unique contractual document entered into by our ancestors more than 170 years ago. It is the founding document for our contemporary society and provides a blueprint for respectful relations between Māori and the Crown. The treaty ought to have a central formal part in our constitutional framework, and the government is currently considering this proposition, and this is part of the agreement between the Māori Party and the national-led government. And so has set up a constitutional review panel. It's really in the last, so it was in September, so a month or two ago, has released a first go. It's raising some of these issues. One of the core issues is obviously what role should the Treaty of Waitangi have if we're going to move into a formal constitution type role? What role should Māori play in that? Looking again at our Māori seats in Parliament. So that constitutional review is going on at the moment. With formal recognition, the treaty would become relevant across the entire legal and political spectrum of the country. But constitutional protection, I believe, is unlikely to give Māori much more legally than Māori already have if the current court or judicial interpretation of the treaty remains a guide. And that's because the court's precedents, as I very briefly went over, has already established this idea. If the legislation, the core principles of the legislation are in direct conflict with the treaty, well then the treaty can be overridden. And there's no suggestion from our courts necessarily that they will necessarily move away from that. So the existing precedents, such as the treaty principles, can be trumped if they are inconsistent with core principles of the relevant statute, and the emphasis on the Crown's right to govern illustrate this point. While the Waitangi Tribunal provides an alternative view to how the treaty principles ought to be interpreted and applied, there is no present developing judicial trend in the courts to adopt this reasoning. Māori often lose in the courts, and so do the Aboriginal peoples in Canada. What then is the solution if it does not lie entirely within constitutionalising rights? For Māori, opportunities exist in influencing legal and policy formation at the national level because Māori have representation in Parliament and Māori tribes have some political strength in negotiating with government. There are also increasing opportunities for Māori to influence decision making at that local, regional level. It is important to recognise these factors, but even so, Māori rights remain vulnerable because in the end, Parliament is and will still remain supreme. Māori rights are vulnerable if the majority public opinion is hostile or unsympathetic to Māori rights. While the treaty ought to form the central part of our constitution, we should not be fooled to think that this would overnight reinstate Māori as partners in creating a new bicultural society. The experiences of Aboriginal peoples in Canada with Section 35 have shown us this. The real route to reconciliation is through education and attaining the hearts and minds of all peoples to support and celebrate the value that Indigenous peoples can bring to developing a strong and resilient modern society. And just to conclude on that, these is an amazing initiative that happened just recently in our country. Some independent body with lots of money funded 50 of our leading students from across the country to spend a couple of days in government, in Parliament, with the sole purpose to bring together a constitution for our country. And these are two students from my university where I teach, who were chosen to be part of this. And the document that they came up with it really represents, I suppose, our youth and our future. They thought the Waitangi Tribunal's recommendations actually should have power, and they should have. So the Waitangi Tribunal should move from just simply giving recommendations to actually making enforceable decisions that the government has to have effect to. The Treaty of Waitangi it wasn't even controversial for them to put it right up front there as the founding document for our country. So I'll just sort of leave you on that, and thank you for the opportunity to be here today.
Well, thank you for that. Really, just there's so much packed into what you've just said, and I know some people might have to just duck out for classes, so if you do have to do so quietly, I want to take a few minutes, though, to have some questions for those who can stay for a few more minutes. So lots to think about. Does anybody have a question? I'll get it started. Just something that occurred to me in your presentation. I mean, there's so many things that I think are really instructive for us in Canada around how we think about constitutionalism and, the significance of entrenching a constitution, because it's all about what actually gets enforced on the ground, right? And so I think you've made that really clear today. One of, as you know, the important doctrines that have developed under Section 35 is the duty to consult. And I'm just interested because you talked about the farce of a consultation that has just recently happened in Aotearoa, New Zealand, but we have arguably farces of consultations here too, even given the doctrine. And I'm just wondering if there is any thinking among scholars working on this in New Zealand about advocating for a more robust form of duty to consult, to accommodate, to take in, to actually meaningfully integrate the interests of Maori in decision making, or whether you've looked at our model and seen how it's, with some successes, but also a lot of disappointments.
So the duty to consult is actually one of those areas where Canada has looked to New Zealand. So your Haida Nation decision, Chief Justice Beverley McLaughlin, in her decision, am I still on? Quotes some of the decisions in New Zealand around consultation. And so New Zealand, that duty to consult, well, it was debated. The Lands case in 1987, the justices there, they were spelling out what the treaty principles were, and they mentioned consultation, but they didn't put a lot of strength on it. And then it's developed through the courts to the point now where the consultation needs to be more than window dressing, is what they say. So it needs to be more than window dressing, but it's not going to be a veto on the options available. And so we're still really at a... we still haven't really got a firm grasp of what consultation is. All the government departments, like government departments in Canada since that Haida Nation case, have really put a lot of work into policy documents around consultation and what that might mean. I think as a country we're still very young, I suppose, in developing what that consultation might mean. And you can see here with the government going about its consultation, even though on the water issue and ownership of water, even though it made it very clear that it didn't really like the options that were being presented, it was obvious to everyone that it was a farce, and I don't think anyone would have really dispute that in some ways. So we're still very much trying to work out that consultation one. The more I suppose we're going to get a better grasp of what consultation is once the tribes themselves, once they've all settled, all have money in their regions, all have that political nous and the strength and opportunities to argue, because as with that redress, treaty settlements, they become owners of property at a local level, and therefore local authorities have to start having regard and listen to that voice of Māori as they become major ratepayers for the county, for the area. And then with the tribal settlements and Māori having more wealth, are able to better influence the national government as well. And then when we have co-management agreements, like for the Waikato River, but also Auckland City, lots of volcanoes in the actual city, I think about 13 volcanoes in the city, that's all going in for co-management with Ngāti Whātua, with the tribe. So co-management opportunities and joint management opportunities are really opening those doors, I suppose, for power and control.
Because everything you've talked about today, it's okay. I don't think everything you've talked about today presumes integration. Does it not?
Yes.
And in a way, the treaty from 1840 has provided that base. Okay. What about inherent pre-colonial Maori law in the area of property, obligation, family, and so forth? Is there any existence or attempt to retrieve that now, to give it recognition and function and institutionalized activity? I'll stop right there.
Yeah. Yes, there is. So, a number of our statutes, legislation, will reference, say, our Resource Management Act. Section 7A states that decision makers in making decisions as to whether to grant resource consents to allow anyone, any company, local authority, anyone to use any land, air or water must have particular regard to kaitiakitanga. So what is kaitiakitanga? It's just defined simply as stewardship or guardianship. And so that allows an opportunity for Māori law around natural resources to have currency in today's context. So a lot of our legislation incorporates Māori law into the actual legislative framework, forcing all of our courts and all of our decision makers to have at least some sort of semblance of understanding and to get their heads around, what is Māori law around this particular area. Again, it's very much so in family, around children, and so very much around family and environmental, mostly. You would see examples of Māori law. But just in terms of that first comment there around integration, I think it's true, and it's probably different to here in Canada in some ways, because we don't have the history of reserves and sort of that being ring-fenced and sort of lived in separate places, or separation. And so there is the integration. Māori feel comfortable in describing themselves as New Zealanders, or Kiwi is the way we describe ourselves. Kiwi after the bird, not the fruit. Or I don't know if it's much better. The Kiwi, the bird, is this large, flightless, blind bird that only comes out at night. So I think in some ways Māori do feel proud about being New Zealanders, and most Māori are working towards seeing a role for for the Crown to be there for governance. There's different. It depends on which part of the country you're from. So in the South Island, right from say the 1780s, 1790s, when you first had whalers, sailors, then missionaries coming over, there's been a lot of interaction from that early eras. But there's other areas, particularly on the east coast of the North Island, that hasn't had a lot of mixing with European peoples until about sort of even the 1960s, 1970s, and that's the Tūhoe area. And they're very strong about their own self-determination, and some in there are quite strong activists, and some would purport that there should be passports to come into their particular area. So we do have enclaves in New Zealand where that strong self-determination exists. Tūhoe have been, so most of that land in Tūhoe area is the Urewera National Park. So the Crown declared most of their lands National Park, even though they still live in that area. And Tūhoe have just, we're talking like weeks, only weeks ago, the government has announced that the Crown has entered into a co-management agreement with Tūhoe around the Urewera National Park, where Urewera National Park is going to come out of Crown ownership, and they're going to move it into more of a neutral stance of like nobody owns that land, so a no-one ownership type thing. But it's quite a major development in the race relations of those two. But if you're looking for this tense relationships, it's definitely Tūhoe and government. Back in maybe about 5 years ago now, even though it's just coming through the courts this year, government had this idea that Tamaiti, who was one of our strong Māori leaders, that he was training a whole lot of young Māori youth up to fight the government. And the government alleged that there were training camps in there, there was militia-type activity taking place in there with guns and bombs, and so our government, it's the only instance where our government used our terrorism legislation to be able to go into that community in dawn at gunpoint, holding up families, ripping people out of homes, children. That whole area of the Ruatoki, that whole sort of area there was under siege by government militia, or not government, government, police and armed defender squad, and they're in there, and through all that, and they arrested so many people, and it was horrendous what they did out there. Eventually, only 4 people from Tūhoi were up on trial in the criminal courts for terrorism, and it's all been squashed. I mean, there was nothing there to it. So we definitely have some instances of that, but generally, it's reasonably kind of respectful around moving forward together as a nation together.
Hi, good afternoon. I was just wondering about your Maori Prime Minister. Is he or she Maori? And the other question is related to spirituality. You talk about water and land rights, resource use. Is there recognition on Maori spiritual connection to land and water? And how is that recognized?
Yeah. Okay, so there's 2 good questions there. The first one, I might not have got, so around our Prime Minister. Our Prime Minister is a white, male, wealthy millionaire, conservative. So that's our Prime Minister. Our Minister of Māori Affairs is a Māori male. He's the leader of our Māori party. He'll be in his late 60s, maybe even early 70s, has a lot of mana authority, has dedicated a lot of his life to education and revitalisation of our Māori language. So that's Peter Sharples as our Minister of Māori Affairs. Or maybe we also have a Māori king, or a king or a queen. Our queen just passed away in 2006, and then her son, he's our king, and based in the North Island and Hamilton, around where you were, Brenda. So we have a Māori king as well. But the Māori king, that movement, that was very much part of European colonisation. So the Māori king, or our kingitanga movement, really established in the 1870s as a protest and as a way for Māori who previously hadn't thought of themselves as one group, whereas they could come together as a group to fight the government over land, take confiscation of land. So that unity around our king. Second question is around water and land and around Māori laws, around Māori relationships with water and whether there's respect for that. So I spoke a little bit about the Indigenous Bar Association, and a lot of my research is on this. So a lot of Māori laws are around not being able to mix waters with another water catchment, definitely not being able to put human sewage, even treated human sewage, into waterways. Should be preference for land disposal systems. So a lot of quite strong laws there around how to interact appropriately and correctly with land and water, and to respect what we call the mauri, the life force of the water. On one part, it's part of answering that. Māori have taken more than 20 cases to our Environment Court appealing decisions that are going to affect the life force of the water. Māori have only won 2 of those cases since 1991, so not a lot of success in that context or that realm. And the other realm, though, is negotiating with the government, and that's where there's been some really exciting developments around our Treaty of Waitangi settlements, where, like the Waikato River in 2010, Māori are now the co-managers of that river and be able to directly influence that. And 6 weeks ago, the government announced of the Whanganui River, which is in the North Island, it's our 3rd largest river, that the government is going to, it's working with the Indigenous peoples there, the Whanganui tribe, and are going to enact legislation that gives legal standing to the Whanganui River. So the Whanganui River, which is an ancestor of the Whanganui people, will have its own legal standing and will be recognised in law as a person. That river will, and this is quite revolutionary, and no other legislation in the world, I don't think, has gone as far as this. It's a Professor Christopher Stone idea from the US about giving legal standing to natural resources that kind of makes sense in a Maori worldview of thinking of the river as our ancestor, and so we're quite excited there that legislation should be enacted, they're saying, at the end of the year. At the moment, it still is an agreement in principle. So there's some really exciting things happening in one realm, and then in the other realm, there's some things that are quite concern.
Well, I want to just on behalf of the Faculty of Law, thank you, Jacinta, for a really interesting talk today and for visiting Winnipeg. We have something to give you. There's just a card, but something to take home and wear with pride. And to keep warm. Okay, thank you very much.
Thank you.